Okey, pagi ni bersama saya ialah Timbalan Pengarah iaitu Pengurusan Media Dr. Khadijah Muhammad daripada Pusat Pengajian Undang-Undang. So pagi ni kalau boleh, kalau katanya kita nak buat macam santai-santai je lah. Kalau kata masa Dr. Jah Dr. tengah present tu, kalau ada persoalan yang nak tanya, kita boleh stop lah Dr. Jah sekejap kan. Okey, video ni kita akan kongsi juga pada semua yang tak main, yang tak join kita pada pagi ni, supaya ahli akademik boleh dapat info lah berkenaan dengan harta intelek yang kita boleh apply lah melalui MyPo. Okey, kalau ikut di sini pengerusi SEFB, Dr. Sheri tak boleh masuk kot saya pagi ni. Tapi Dr. Razia daripada IBS ada. Ya, Dr. Razia.
Ya, saya ada.
Ada. Okey, terima kasih Dr. Razia.
Sama-sama.
Okey, kalau macam tu kita boleh mula kot Dr. Jah.
Okey, baik. Terima kasih Dr. Kofiza. Assalamualaikum warahmatullahi wabarakatuh. Selamat pagi, salam sejahtera. Sebelum kita mula, saya nak pastikan dengan pengerusi Jawatankuasa Inovasi di Pusat Pengajian, kita ada international staff tak dalam sesi kita sekarang ni? Ada dekat IBS ada Dr. Mahfujur. Okey, kalau ada international staff tu maknanya the session will be conducted in English lah. Sekejap lagi tak fair pula kan untuk mereka. Boleh. Okey, tak apa. So saya mulakan je lah ya. Ya, sila. So to start with the session, I will introduce our office first, Innovation and Commercialization Center of UUM. Where is our office located at? It is actually in the same building with the RIMC, and in fact at the same level with the RIMC, and below us is SETMA office. So for those who do not yet know about our office, so our office is located at Pusat Convention, opposite the Chancellery building. So I will explain briefly what will be the main function of ICC. Okay. So we had been given a responsibility to help the university citizen in terms of managing intellectual property. Saya nak senyum sekejap sebab ada nampak ni on my screen that abang handsome. Okay. So the main function of our office is that to assist the university citizen in terms of managing your IP, intellectual property, that derive from your research output. Okay, your research output. And secondly, once the IP output had been registered, if the product or services that resulting from your research output have a good potential to be commercialized further, then it is also our responsibility at ICC to help you further on how that we can take a commercialization steps in order for you to commercialize your product or services. So that are the two main functions of our office. Okay, so I will just go straight away explaining what is meant by intellectual property. So it is basically an umbrella term, okay, covering three components of IP, but in general, it is actually referring to a types of property that result from the creation of the human mind. So it is actually an intellectual product that we produce based on our nature of work as academician, And in fact, university is also considered as one of the research institution, apart from our traditional role that is teaching. Research and development activity is also become our role as well. So if we would like to make an analogy referring to the type of intellectual property with the one that conventional or traditional property or other tangible properties, okay? For example, that other tangible properties, the usual one that we already understand, for example, that when we buy a house or we buy a vehicle or car, or when we deposited our saving in the bank in a form of money, or perhaps that we are also interested in collecting or in saving in a form of gold. So those are the tangible properties that have certain value, okay? As well as, for example, that perhaps we also consider the intangible type. For example, that we have or we own shares in a company. So that one also considered as valuable property. So those tangible or traditional property that we've already understand the concept of it can be owned, can be transacted, meaning that it can be sold, it can be bought, and also we can use as a security for a financial loan. For example, that we can charge our house, we can charge our land, for example, or we do a mortgage for our property to the bank in order for us to get the financial loan or financial assistance. And also, this traditional property can be inherited to our beneficiaries. So the similar characteristic or similar concept of traditional property actually applicable to the type of intellectual property. So meaning that, let's say that from our research, we have certain copyright. Okay, we have certain copyright, or perhaps for some researchers based on the nature or the background of our academic, that they can invent something that might be benefit for the society when it fulfill the criteria, certain criteria. So perhaps that they are registered under patent. So meaning that your copyright or your patent is considered as one of the branches under the big concept of intellectual property. So now we need also to aware, okay, we need also to aware why IP is given an appropriate treatment or protection by the law, not only in Malaysia, but throughout the world, yeah? Okay. IP can be used as a capital expenditure for new products. It is also very important in terms of the R&D activity and ecosystem. It can also be used as a marketing and advertisement. For example, that let's say that one of the output from our research grant is that we produce a certain distinguished product, for example. So our distinguished product, once let's say that we register as a brand or trademark, so that particular trademark can be used as a marketing and advertisement strategy for our business. And IP also is given wide free riders from using the protected IP created by somebody else. So for example, here, if, for example, that if we publish an article journal as one of the research output from our grant, we have to ensure that we do not include anybody that is not relevant or not contributed at all towards the creating of that article journal. And also, once it is published, if anybody else would like to use or to refer to our published article journal, they have a responsibility from the perspective of law to make a proper acknowledgement. If not, then it is considered as a violation of our copyright or infringement of our copyright, or in a context of layman terminology, it is a plagiarism. So when it is a plagiarism, we can actually take action to those who violated our rights. Okay, and also IP is functioned to maintain our loyal followers, especially in the case if we have a certain products or services, and also, of course, when it is commercialized, it is for the main purpose to get the profit from those IP that we created. Okay, and also why the law give a proper protection towards IP rights holders. It is considered as to ensure the justice for the person putting in the work and effort into an intellectual creation. So in the context of university, we as the researcher, when we conducted our research project, definitely at the end of the research project, we can produce something. So that's something we need to identify which suitable IP types can be protected from our research output. Okay, and it also to encourage such work to be grown, as people see that such work can bring a financial return. Okay, and also IP rights protection will help to extend protection to such things as the unwritten and unrecorded cultural expression of many developing countries, generally known as folklore. So this one, the last one, for example, that whatever the culture as practiced by our generation that inherited from our predecessor, for example, from our ancestor, that one, there is no specific statute saying that it is actually protected under our local law, our law. However, although there is no specific statute saying so, it is actually protected under the law. Why it is how it is protected under the law, that we're using a principle under the common law. So unrecorded cultural expression, for example, that some petua, I'm not sure in English what we call it, a petua. So I believe that it is a common practice in our generation or in certain ethnic, that one has been passed from our ancestor, and we also will pass such practices, certain practices towards our future generation. For example, that perhaps that in preparing certain traditional dishes, for example, or perhaps that in our effort to preserve certain traditional dance, zapin, for example. So those are belongs to unrecorded cultural expression that is actually protected under the law. Okay, so to make things easy to understand the concept of IP, it is comprising of the three components. The first one is copyright. Copyright specifically protecting for literary and artistic work and all types of other categories that belongs to copyright. So copyright, it is actually an automatic protection once all the criteria to get or to be entitled as considered as copyrighted work has been fulfilled. Okay, the second component is falls under the category of industrial property. So for industrial property, we have patent, we have trademark, we have industrial designs, we have geographical indications, we also have layout designs of integrated circuit. So for the category of industrial property, all this one, we have a specific statute regulating on each issue, but in contrast to copyright protection, that is automatic protection. For industrial property, every single type must be registered to ensure that we are fully protected under the law. And the last component, the third component, is those that are not registered under any statute, and in fact, there is no such particular statute governing these types, but still anybody cannot just copy or violates the IP protected under this component. Why? Because it is protected using the principle of common law. Using the principle of common law, meaning that we are referring to whatever the court and the judges decided through cases. So from the cases, it was established a rule, regulation, and the law about every single aspect that belongs to the protection under common law. That is, either we protect it as a trade secret, or we protect under the passing off. Passing off is actually a subset of trademark, but for the category of unregistered trademark. So meaning that even though for the unregistered trademark, we cannot simply copy and imitate and use as our own, that belongs to others. Why? Because it is still protected under the law. And also the unfair competition and misappropriation doctrine, these two can be used as a legal defense if anybody just copying our product that protected under this component. Okay, so I will go, okay, before I go into each category, this one is IP in brief, meaning that sometimes in one single product or services that we can produce or that we can protect, okay, it has more than one category of IP that we can register. For example, here, for the Coca-Cola, the logo and script design of Coca-Cola, the company actually protected under copyright and trademark, okay? The distinctive shape of the Coca-Cola bottle, that one is also protected under trademark. In terms of the method of making barrier-coated plastic container for the Coke bottle, that one is protected under patent, okay? And also the shape of Coca-Cola bottle, originally it is actually protected under design, but one of the limitation of design, it has a certain limitation period of protection, and after the period lapse, it can no longer be renewed. So once it is not renewable, it become or it will go into the public domain that open for everybody throughout the world to copy and use and produce the same shape. So that is why later on, with certain modification, Coca-Cola registered their shape bottle, okay, under the category of trademark. So now we go to the first category that is close or can be closely associated with the nature of the work of academic. The first one is copyright. It is protects original works such as literary, musical, artistic, films, etc. that attributed to the skill and labor of an author in the creation and expression of an original idea. So meaning that copyright, it only protects original works. What does it mean by original works? So actually for copyright, it is an automatic protection once the three criteria as appeared in the screen now, once these three criteria has been fulfilled. So it is an automatic protection. So the first criteria that we must fulfill in order to ensure that our works created entitled for the original status. So what does it mean by the originality? The work is original if sufficient effort has been expended to make the work original in character. So originality here, meaning that the first one, we cannot just simply copy or imitate from the work of somebody else. If we use other works as a reference to our current work, we must ensure that we actually put our sufficient effort by using our own skill and labor and expand those skill and labor towards that work to ensure that the end result is actually original in character. Original in character meaning that our own contribution that make it or make the work as an original in character. Okay, so meaning that if it is simply copying from others' copyright, it is not considered as an original in character. So when it is not original, it is failed to fulfill the first criteria. Okay. Once we ensure that the work is original, the second one, the work has been written down, recorded, or reduced to material form. Okay, the second criteria means that the law does not enable protect an idea. Okay, if it is an idea that stored in our own minds, or perhaps that we have such an idea, we discuss with other friends for 3 months. Let's say that every day we discuss about that particular idea with somebody else, but we never do or we never take any action to ensure that our idea has been transformed into a material form. So into a material form in this context means that either we write the idea down into a paper, for example, or we recorded, perhaps that we recorded our voice, or perhaps that when we talk about we want to create a song plus with a music, so that one must be ensured to compose into a recorded form, meaning that when we compose a song, perhaps that we record in a computer, okay, together with the whatever music that we produce together with the song that we compose. So meaning that the law does not protect the original idea, but it is only protect the expression of such idea that can be reduced into a material form. The third one, the third criteria, the creator, who is the creator? We are the one, okay? The academic or any citizen of Malaysia. So the creator must be a qualified person. Qualified in this sense, meaning that those who have a citizenship of Malaysia or the permanent resident of Malaysia. Let's say that we have our co-partner, or perhaps that in our research project, we also have a team member consisting them of an international staff, okay? Can they also claim a copyright protection in Malaysia? Yes. Subject that the work created by them or contributed by them has been made in Malaysia or first published in Malaysia. So meaning that there is no barrier or no limitation in terms of, let's say that our team member consisting also our fellow from international staff. Yeah? Okay. Here is the example of copyright category. Okay, I will skip this one to make things easier to understand. So here is the category protected under copyright. we have the first one on the literary. On the literary category, it is much more related to the nature of our academic work. For example, that in fact, our lectures note subject that we are not copying from others and we are not using images from internet that had been protected under someone else copyright. Okay, so our lecture notes can also be protected under copyright. Okay, so in terms of research output, usually in this category of literary, so far ICC received a lot of application from researcher that perhaps they want to copyright the model. For example, then if we look into the FRGS research project, usually one of the output is to come out with a new model, for example. So such model can be actually protected under copyright under the literary work category. So for artistic, for example, that if anyone like to or your hobby is that to take a photo, so such photo originally taken by you, that one also can be protected as a copyright under the category of artistic work. Okay, and perhaps that for those who have interest in musical, film, or sound recordings, so those works, if you can create or produce, but this one, as far as I am concerned, in UUM, for example, for musical, film, and sound recording, perhaps that more related to our colleagues in SKIMPA, and perhaps a few from also from the School of Computing, but it is not necessarily limited to them. We also, if you have a certain interest or perhaps that certain talent in such area, so you can also produce a musical, film, or sound recordings work, as well as the broadcast. Yeah? And also, the last part is about derivative. Derivative also closely associated with the nature of academic. Why? Because sometimes we need to do a translation. Perhaps that we want to publish a book, but it is a translated version. That translated version also have its own copyright. Okay, so that's all for the copyright category. Any questions so far? Ada soalan tak? Kalau tak ada, kita kita teruskan je kepada okay. Okay, what we have for copyright, even though it is an automatic protection, but my IPOs starting from 2012, they realized that in order to avoid any dispute or claim concerning of the copyright ownership, so my IPO is a governing body handling all issues on IP, including our registration. Okay, so they introduced in the statute a copyright voluntary notification system. So what we did so far at ICC is to assist all UUM staff in order for you to get the registration of copyright voluntary notification system. So if among the audience today who already have certain numbers of copyright already registered with us, so this is actually falls under this category of voluntary notification system. And if you have a chance to browse through ICC website, in the column for people to download, there is a form ICC 01. So that one is actually an application form. So if you want to apply for the copyright protection, so you need to fill in ICC 01 form. So once you submitted the form to our office, our staff will later on assist you it is actually not a personal assistant, but this is what we did at ICC, that we will fill up the form CR1 as available in the My IPO website. And also we will prepare the statutory declaration that need to be signed by all researcher or applicants for the IP. Okay, meaning that if you have any output from your research grant that you need to apply for copyright protection, you need to include all the team members, and in the column of the form, we need to also know what will be the percentage of contribution of each team members and how many from the leader. Okay. We will also prepare the statutory declaration that need to be signed by all applicants, meaning that the leader and team members. That one is also on that one is on the part of the applicants, as well as the statutory declaration from UUM. So far, the statutory declaration from UUM has been signed by our TNCPI, and also the prescribed fee. This one will be handled by our staff at ICC. So what will be the task of the applicants? You just need to fill up the ICC 01 form and submit to us, and the rest we will manage. And once the registration had been settled, that we get the certificate from My IPO, ICC staff from time to time will also notifying the applicants about the status of your application. Yeah. Okay. So here we have some examples from our colleague at SEFB as well as at IBS. Okay, we have, for example, that Dr. Shri also up to now have several IP already registered with us, and in fact, one of the copyright of Dr. Shri already be commercialized in January this year. Okay, in January this year. That one is about the hydroponic kit. So we also have several copyright registered from our colleague at IBS. For example, here in the screen, we have the one from Dr. Adib. Dr. Adib also have several copyrighted works already registered with us, as well as this one from Associate Professor Dr. Muhammad Shahril, also from IBS. Yeah. So this one is for the category of copyright. Okay. So here also example of the successful copyright that already been commercialized. Okay. For example, that if you look on the left side of the screen, it is actually Keep Bijak Wang by a team from UPM that already commercialized and been used by schools, primary and secondary schools in Malaysia, as well as at the university level, those who get the financial assistance from the PTPTN. PTPTN also supplied them with a Keep Bijak Wang. So you can see the potential, even though it is we only register under the category of copyright, but some products have a good commercialization potential that can give a financial profits as a return of your skill and labor that you spend when you did a research project. Okay, so now we start with the category of industrial property. The first one is about patent. Okay, patent protects invention. Okay, patent protect invention, which permits in practice the solution to a specific problem in the field of technology. So patent, you must ensure that whatever invention that you invented, in order for such invention to be eligible under patent protection, okay, you must ensure that that invention you create something about the invention to solve a specific problem that relates to something in the field of technology. And for patent, for the invention that will be eligible for protection under patent, it can be either as a product or also as a process. For example, here in the screen, for product, for example, that if you invent a food container, so that food container, if it fulfills the criteria for the patentability, then it can also be registered as a patent. And the same food container, but if you invent further a method for manufacturing microwavable food container, so that process of manufacturing, is also entitled for a patent protection once it fulfills the criteria of patentability. So what will be the criteria of patentability? We have three criteria. The first one is new. New means that the invention has not been publicly disclosed in any form anywhere in the world. New here, if you realize that when we want to apply, for example, the FRGS grant from the KPT, starting from last year, KPT also make one of the compulsory requirement for the researcher to also attach or supply the information about patent search, okay, about patent search. So that patent search is actually to ensure that whatever product or process that we intend to invent from our research project, okay, the KPT just want to ensure that it is not similar for whatever available existing patent that already protected by somebody else. So that is the purpose of why there is a requirement for the patent search by the KPT now. Okay, so once it is passed, the new requirement or the novelty requirement, we also must ensure that our invention must also fulfill the second criteria, that is, the invention must involve an inventive step. To make things easy to understand, what does it mean by inventive step here? Let's say that if we invent something about a process, okay, about process, let's say that it is about a computer software. So inventive step here means that if other researcher with the same academic background, similar field with us, the inventor, they can explain what are the process in order for them to produce the similar computer software, for example. So meaning that if they easily can identify what will be the whole process, let's say the computer software that we produce involves 10 steps. But when we ask other researcher with the same academic background as us, they can also easily identify all those 10 steps. So meaning that our invention does not pass the requirement of inventive step. So inventive step here means that if our invention, if we ask to those experts with the same academic background, they also cannot explain the 10 steps or the 10 secret ingredients that we put in our invention, then only it will pass the requirement of inventive step. So meaning that, make sure that other researchers with the same academic background with us, they cannot simply, or it is not obvious for them. If we show our product or process, it is not obvious for them to understand, to identify, or to explain whatever steps that involve in our invention. Then only it passed the second criteria of inventive step. And the third one, the third criteria is our invention must be industrially applicable. Industrially applicable here means that it can be mass produced and also can be used industrially. Okay, so that one is for patent. As today, for UUM patent, we already granted one patent for invention for easy rule. Okay, this one is actually, as a result of KIQ project of our colleague at JPP. So they are not academic. They are not academic. They are admin staff who involve with everyday tasks, and especially for those at JPP, when there is any event in UUM that involve the VIPs, for example, during the convocation, they need to prepare the Dewan Mas with appropriate equipment and facilities. One of it that they need to use carpet. So can you imagine the size of our Dewan Mas? If our colleague at JPP, if they want to do it manually, so of course a lot of staff will be involved, and also it is a very tiring process for them, and also perhaps that take more times in order to ensure that everything is fully equipped and all facilities are in order. So they come out with the idea that perhaps by using a certain machine in terms of preparing the carpet at Dewan Mas, for example, that it can take less time and less staff involved. So less manual work involved in what we call it in preparing the Dewan Mas, for example. So they come up with the idea. They prepare a prototype for this one, that, and then they apply for a patent registration. And after 5 years, this one is actually has been filed in December 2015. And only in November last year that we get the notification from my IPO that this invention has been granted as a patent award or patent granted. So for patent, it does not mean that once you file, you can claim that, oh, I've already have a patent. No. Why? Because it is the standard operation procedures at my IPO, and in fact, in all IPO office throughout the world, that they need 5 years from the filing application towards the period of decision whether or not the invention can be granted a patent or not. So it is involved a 5 years period. Okay, so if it is only you just only file a patent application, we cannot say it that we already have a patent. But that one, the legal terminology used is a patent pending. So meaning that during the patent pending, it can be either your application will be granted with a patent, for example, that the one that we discussed previously, or my IPO can also reject your application. So when it is rejected, okay, it will not be a patent granted. Why it is rejected? Sometimes it is rejected because of one of the criteria. The most significant is about the inventive step criteria has not been fulfilled. For in such cases, my IPO will offer only utility innovation. So we will proceed with the protection of utility innovation. Okay. So the second category is trademark. Trademark actually protects science. Okay. And science, it may consist of word, name, signature, shape of goods, or their packaging, etc. Okay. We have, for example, here our UUM logo. That one is protected under trademark. Under trademark. And another case that we can highlight here is about the Manager's Coffee. Manager's Coffee is also a trademark, belongs to UUM. And in fact, when we registered Manager's Coffee in 2016, the Manager's Coffee trademark has won a bronze prize during the Harta Intelek Negara in 2018. Okay, so this one is example of the traditional mark. Okay, now with the current development of the law in Malaysia, we in fact have a new Trademark Act 2019 that come into force since 27 December 2019 because of our country's accession towards the international requirement. Okay, so now under the new law, we also have 4 new categories of trademark. So if we have a good shape of goods or their packaging, okay, this one can be also considered to apply for a trademark protection. For example, that the shape of goods or their packaging. Shape of goods here, if you look into the below, but in the center of your screen now, chocolate Toblerone. Okay, the triangle shape of chocolate Toblerone, and perhaps that the shape of potato chips from the Pringles. These are examples of types of shapes or their packaging that already been registered and protected under trademark. The second one is about sand. Now we can also register sand as a trademark as long as it fulfills the criteria for trademark protection. Okay. The third category is sound. Sound also can be protected under the trademark protection. And the last one is single color. Okay, single color can also now be registered as a trademark. Okay, the next one is about industrial design. Industrial design, okay, protects the visual features of objects containing aesthetic values, meaning that for design category, it must be have a characteristic of aesthetic. Aesthetic means that it is beautiful in the eyes of the consumer. So in our eyes, it must be beautiful in our eyes, and it can be protected either in 3D form, okay, or 2D form, okay. I just would like to share with you the example here in 2D form. For example, that if we can see the drawing of owl on the left side of the screen, and also at the center below, the drawing of some what we call it botanical flowers, if I can say that. So that one is in 2D form. The 3D form of design, for example, that the bottle of honey, okay, the bottle of honey on your right side in the screen, and also some flowers on the vehicle tires, okay. Those are protected under design. And in terms of UUM case, at the center, if you realize that during our recent AGM, that all the exco's wearing a purple batik, okay. So the motif of bougainvillea flowers, apa ni, at Batik Sintok, okay, already registered. They registered actually about 9 design of the flower motif, okay, as a Sintok Batik. So this one is one of the product already registered under the design protection that belongs to UUM. Okay, the next category is about geographical indication. Geographical indication also protects signs similar to trademarks, but the only difference is that for geographical indication, it protects signs that attributable to the geographical origin or location. So meaning that, for example, here, for Harum Manis Perlis, it is actually protected under the geographical indication that belongs to Jabatan Pertanian Negeri Perlis. Yeah? Okay, the last part in this session is about integrated circuit. It is also the last category in the industrial property component. So integrated circuit, to make things simplify and easy to understand, okay, I just refer as a motherboard in the layout of a computer devices. Okay, so that design, the layout design of chip, computer chip or motherboard also been protected under the law. Okay. Okay, another category that is protected under common law principle is about trade secret. Trade secret involve any important and commercially valuable confidential information. So meaning that if we have any valuable confidential information, either it is about a business method, for example, or certain formulas, for example, that we can actually protect under the trade secret. For trade secret, there is no formal requirement for registration by my IPO, but we at ICC, we have a certain procedures to follow when we handling with the trade secret issue. So far, we have already registered 3 trade secret formulas from the product of Dr. Risha and team from STML. Okay, so here is our team members at ICC. So if you have any question later on, you can contact us from time to time. Our director is Associate Professor Technologist Dr. Muhammad Faizal Omar. He is also responsible to head for the commercialization unit that is assisted by our officer, J. Azri, and I actually had been tasked to lead on the IP management unit, and I am assisted by Dr. Kofiza and also Puan Intan. So usually Puan Intan is the one that liaise with you in terms of processing your application to my IPO. And at our office, we also have Encik Afnan that responsible for the administration and financial matters. Puan Liza under the commercialization unit that will assist Encik Azri and our director, and also our secretary, our office secretary, Puan Hasnita. So I believe that that's all of our sharing today. Any questions so far? Dr. Kofiza already shared a link on ICC 01 form. If anyone in the session today would like to see the look about the form, then you can click the link shared by Dr. Kofiza. So with that, thank you, and I welcome any question or any discussion or any issue that you would like to ask us at ICC.
Assalamualaikum Dr. Khadijah.
Ya, waalaikumsalam. Dr. Zalina
Ya, saya. Dr. Khadijah nak tanya, if let's say I would like to apply for copyright, let's say I have some product kan,
Ya.
how can, ada tak database, how can I check whether benda tu memang dah ada dalam database my IPO? Maksud saya, public can check or not? Or ICC only can check?
Okay.
Because I'm not sure, right, whether benda tu dah ada ke tak.
Okay. For copyright, there is no specific database for copyright. Why? Because as I mentioned just now, the concept of IP for copyright only, it is an automatic protection kan? But it is only the effort of our government to introduce a voluntary notification. So there is no other means for us to check about the copyrighted work. However, what we did at ICC, if the applicant submit, for example, let's say that you want to copyright a model. So usually the question, the basic question we ask, whether or not that particular model has been developed by your team from scratch? If the answer is yes, then we will process further. If the answer is not, then we would like you to put or to mention from which model that you are referring to. So when you put the reference to your model, then only we can assist you further, whether or not you need to do a certain modification, whether or not you should avoid using the original one, but perhaps that you can take the idea and develop something else that can differentiate from the original one. Jelas tak, Dr. Zalina?
Okey, jelas.
Okay, kalau kata tak mau share kat sini, nanti boleh contact personally Dr. Fiza. Dr. Fiza memang akan bantu
Okey.
untuk ni lah, untuk application semua
Okey. Sebab saya ada satu pertanyaan daripada ICC lah berkenaan ni kan. So
Ya.
saya check tu, saya duk fikir macam mana saya nak check? Saya cari dekat website tak ada kan. Mungkin
Okay,
ICC
kalau
boleh
boleh Dr.
access
Zalina share
that's
yang
why.
Dr. Zalina punya application tu berkaitan apa?
Yang baru ni yang straw padi tu.
Straw padi.
Oh, okay, straw padi.
Ya, yang Dr. Jah ada komen tu.
Okay. Kalau yang straw padi tu mungkin boleh tengok sebab untuk straw padi ni tahun 2006 atau 2008 kalau saya tak silap, apa ni, Jabatan Pertanian Negeri Selangor lah kot, mungkin di kawasan Banting dengan Sekincan tu. Mungkin boleh semak di situ.
Itulah saya browse tu tak jumpa benda tu kan. Tu saya tanya tu mungkin ada certain channel yang ICC boleh access ke, kita tak boleh access ke, itu yang saya.
Kalau boleh saya tanya terus kat
Kan?
sini lah. Maknanya
tak
masa
apa.
yang tu daripada grant research ke macam mana?
Tak ada. Ni tak ada geran apa.
Tak ada, tapi macam mana mula idea untuk cadangkan straw padi tu?
Idea asal bila ada yang kerecut bersemua tu kan.
Okay.
Daripada exactly from plant tu. Memang daripada kerecut bersemua tu. Memang idea purely macam tu je lah. Maksud dia ada dah yang diterbitkan yang dekat Vietnam semua tu kan, yang pakai pokok saja tu kan.
Yang tu lah, maknanya itu
Jadi
yang
tak
kami
ada
masukkan tu. Kalau ada reference yang macam tu, minta tolong doktor masukkan dalam borang tu. Maknanya yang tu yang kita kata.
Maksudnya kita
kami nak
support dengan reference macam tu lah maksudnya.
Ya, betul. Sebab when we claim that this is our own original idea, sometimes when we ask for that, it is not originally come from us, but it only come to us when we read something that very similar. So kami nak rujukan tu. Sebab kita kena pastikan kita tak langgar copyright orang lain, sebab risiko dia ialah kalau kita daftar sedangkan kita tak pastikan sebenarnya dah ada orang lain yang dah daftarkan, nanti tindakan undang-undang tu datang balik kepada UUM.
Okey, faham.
Kita nak
yang ini kita letak reference je lah ya.
Ya, kalau yang kami minta selalunya kami nak rujukan tu.
Okey.
Clear
No problem.
Okay, thank you Dr. Zalina.
Thank you Dr. Khadijah.
Ya, thank you juga sebab willing share dalam sesi ni. Sebab dia sangat bermanfaat. Okay, ada soalan lagi tak? Kalau tak ada soalan, okay, saya juga nak share di sini. Every Tuesday, we have the ICC help desk. Tuesday afternoon at 2:30. So every Tuesday at 2:30, if any one of you have any problems, that you are welcome to make an appointment or you just walk in, come to our office. We will assist you on whatever concerns about IT matters. So with that, perhaps that we can end the session. Dr. Fiza?
Ya.
Okay, thank you.
Okay, terima kasih Dr. Jah. Okey, kalau siapa-siapa yang ada pertanyaan berkenaan dengan pengurusan IP ataupun juga pengkomersialan, maksudnya dah ada IP sebelum ni dan ada pihak industri yang berminat dengan produk-produk yang dihasilkan melalui IP itu, boleh datang ke ICC. Kita ada 2 tim di ICC ni. Satu tim yang pengurusan Harta Intelek dan juga pengurusan pengkomisionan. So pengurusan komisionan ni lah Cik Azri yang akan uruskan bersama dengan pengarah. Jadi kalau ada apa-apa boleh datang ke ICC. InsyaAllah kami akan bantulah sedaya mungkin lah, sebab kita tak mau produk IP yang dihasilkan oleh ahli akademik ini bukan sekadar hanya IP, tapi kita kalau boleh kita nak komersialkanlah supaya orang kenal kita tu siapa dan juga di mana kita ni berada kan, sebab kita ni jauh di utara berbanding dengan universiti-universiti lain yang berada di bahagian Kuala Lumpur sana. Jadi saya rasa sampai takat ini dulu. Saya akan share video ni bersama dengan pengerusi jawatankuasa. Pengerusi jawatankuasa akan share baliklah dengan ahli akademik di pusat pengajian. InsyaAllah kita boleh teruskan lagi dengan sesi hands on macam mana nak mengisi borang IP yang saya share link tadi tu, supaya kita bukan sekat mencapai KPI pusat pengajian, tapi juga untuk melindungi idea-idea yang kita ada. Okey, kalau macam tu sampai takat ini saja. Saya akan share attendance sekali lagi. Kalau yang belum scan, minta mohon scan ya. Okey, sampai takat ini saja. Assalamualaikum.
Waalaikumsalam warahmatullahi. Ada sesi bergambar tak?
Boleh, saya terlupa. Minta mohon on video supaya saya boleh screenshot
Ya. So tak boleh tunjuk dekat sekolah mana buat sesi ni juga.